Before we begin, a quick and important disclaimer. The following content is focused on the historical trends and statistical analysis of revenue within the legal sector, specifically relating to matrimonial law in the United States. This video is created strictly for educational and entertainment purposes. It does not constitute legal, financial, or investment advice. The figures discussed are based on historical industry averages and macroeconomic data, which may not reflect individual firm performance or current market volatility. Viewers are strongly encouraged to conduct their own due diligence and consult with licensed professional advisors before making any business or career decisions. Every single year in the United States, roughly 750,000 marriages end in dissolution. While that number represents a personal tragedy for millions, it also fuels a specialized machine that generates over $13 billion in annual revenue. Most people see divorce as a social phenomenon, but if you look at the raw data, it is one of the most recession-proof financial ecosystems in the American economy. We are looking at a sector where a single high net worth case can generate more revenue in 6 months than a standard retail business makes in 5 years. But the real shocker isn't just the total volume of money. It is how the revenue per attorney has decoupled from the actual divorce rate. Even as divorce rates hit a 40-year low, attorney revenues are hitting all-time highs. If the number of cases is going down, why is the pile of money getting bigger? Today, we are opening the books on the secret financial history of the American divorce industry, from the era of no-fault legislation to the modern rise of the million-dollar retainer. By the time we finish this masterclass, you will understand the exact economic levers that dictate how legal wealth is generated in the U.S. Whether you are a law student, a financial analyst, or simply someone who wants to understand the hidden mechanics of the American legal system, this deep dive provides the roadmap. We are solving the mystery of the legal revenue gap and showing you step by step how the business of ending marriages became a multi-billion-dollar pillar of the U.S. GDP. To understand where the money is today, we have to look at the seismic shift that occurred in the late 1960s and early 1970s. Prior to this era, divorce was a fault-based system. To get a divorce, you had to prove adultery, cruelty, or abandonment. From a revenue perspective, this was a high-friction, low-volume business model. Attorneys spent hundreds of billable hours hiring private investigators and gathering physical evidence just to earn the right to file. The barrier to entry for the consumer was so high that the market was artificially suppressed. Everything changed in 1969 when California, under Governor Ronald Reagan, signed the first no-fault divorce law. This was the big bang for legal revenue. By removing the need to prove wrongdoing, the friction was removed from the transaction. Suddenly, the addressable market for divorce attorneys expanded by an estimated 40% in less than a decade. We saw a historical trend where the volume of filing skyrocketed, creating a massive influx of cash into family law firms that had previously been considered a quiet, backwater niche of the legal world. As we examine the historical data from the 1980s, we see the professionalization of the billable hour in family law. This was a crucial evolution. In the early 20th century, many attorneys worked on flat fees or modest retainers. However, as the complexity of American assets increased, with the rise of 401ks, stock options, and suburban real estate, the time required to untangle a marriage grew exponentially. Attorneys realized that charging for the result was less profitable than charging for the process. Let's look at a case study of a standard mid-sized firm in a metropolitan area like Chicago or Atlanta during this period. In 1985, a standard divorce might involve a house, 2 cars, and a savings account. The revenue per case was relatively predictable. Fast forward to the late 90s, and the introduction of digital assets, complex pension valuations, and the valuation of celebrity or professional goodwill changed the game. Attorneys weren't just lawyers anymore. They became the coordinators of a financial task force. This shift allowed firms to bring in secondary revenue streams by partnering with or employing forensic accountants and vocational experts. The revenue model shifted from a solo practitioner model to a leveraged firm model. In this structure, a senior partner might bill at $500 per hour, while an associate bills at $250 and a paralegal at $100. By delegating the heavy lifting to lower-cost employees while billing the client for every minute of total firm time, the profit margins of divorce firms began to rival those of corporate M&A firms. We must also analyze the impact of the Great Recession of 2008. Most industries collapsed, but the divorce legal sector showed a fascinating statistical anomaly. While the number of divorces actually dipped slightly in 2009, Largely because couples couldn't afford to sell their homes or pay for two separate lives, the revenue for high-end attorneys remained stable. Why? Because when assets lose value, the fight over what remains becomes more intense. The cost of conflict is a primary driver of revenue. Historically, the more volatile the economy, the more hours are spent on asset protection and valuation disputes. In a high-stakes environment, a divorce attorney's revenue is not tied to the happiness of the client, but to the complexity of the client's portfolio. For example, in a stable market, a house is worth $500,000. Both parties agree. Total billable hours, too. In a volatile market, one party claims the house is worth $400,000, while the other claims it is worth $600,000. Now, you need appraisals, expert testimony, and depositions. Total billable hours, 20. The revenue for the attorney decuples simply because the economy became more uncertain. Furthermore, we have to look at the geographic concentration of this revenue. It is not evenly distributed across the United States. Revenue hot zones exist in specific jurisdictions like New York County, Los Angeles County, and Miami-Dade. These are high-asset jurisdictions where the legal precedent favors long, drawn-out discovery processes. In these areas, the average revenue per case can be 5 to 10 times higher than the national average. Statistics show that an attorney in Manhattan may generate $1.2 million in annual revenue, whereas an attorney performing the exact same volume of work in a rural county in Ohio might generate $150,000. This is due to the asset density of the local population. Another significant factor in the historical revenue climb is the litigation arms race. As one side hires a high-powered, expensive firm, the other side feels compelled to do the same to maintain leverage. This creates a feedback loop where the price of the service is driven up by the perceived stakes, rather than the actual labor involved. We see historical trends where firms began branding themselves as aggressive or high-end boutique, allowing them to command premium retainers. A retainer is essentially an upfront deposit on future earnings. In the 1970s, a $1,000 retainer was standard. Today, in elite markets, we see historical examples of initial retainers, ranging from $25,000 to $100,000 just to open a file. This provides the firm with immediate liquidity and a guaranteed revenue floor. Step by step, the industry has moved toward a consultancy model. The modern divorce attorney is no longer just a person who files paperwork in court. They are the CEO of a temporary corporation created for the purpose of liquidation. They manage real estate agents, tax professionals, child psychologists, and private investigators. Every one of these touchpoints can represent a billable moment or a strategic advantage that justifies a higher hourly rate. We are also seeing the emergence of unbundled legal services and legal tech as new revenue drivers. While the high-end market focuses on the wealthy, the mass market has moved toward automated or semi-automated systems. This allows firms to handle a much higher volume of simple divorces with minimal human intervention. While the revenue per case is lower, the profit per minute of human labor is actually higher. This scalability is the newest chapter in the statistical history of the industry. By analyzing these patterns, we see that the divorce attorney's revenue is a reflection of the complexity of American life. As we move deeper into this 10-part series, we will break down the specific billing codes, the marketing psychology used to attract high-net-worth individuals, and the specific states where the law is written in a way that maximizes billable hours. We are just scratching the surface of how this $13 billion engine actually runs. The history of this revenue is the history of the American family's financial evolution. To understand the mechanics of the $13 billion engine, we must examine the architectural shift from the general practitioner to the hyper-specialized litigation boutique. In the mid-20th century, a lawyer was often a jack-of-all-trades who might handle a real estate closing in the morning and a divorce filing in the afternoon. However, the statistical history of the industry shows a sharp pivot toward specialization starting in the 1990s. This was not just a change in title. It was a fundamental reorganization of how legal fees are structured. When an attorney specializes exclusively in matrimonial law, they can justify a significant premium on their hourly rate. This premium is based on the historical trend of increased complexity in state-specific case law and the necessity for deep technical knowledge and equitable distribution. Imagine a client named Sarah living in a high-cost area like Northern Virginia in 2026. Sarah is not just looking for a lawyer. She is looking for a specialist who understands the nuances of federal government pensions and restricted stock units. In this scenario, the revenue generated for the law firm is not just a flat fee for filing paperwork. Instead, it is a cascading series of billable events. Each event is a step in a larger strategic play. First, there is the initial consultation, often billed at a higher rate than subsequent hours to filter for high-value cases. Then comes the entry of the appearance and the request for a temporary order. In the U.S. legal system, the temporary order stage is a massive revenue driver because it sets the financial status quo for the duration of the litigation, which can often last 18 to 24 months. We must look at the data regarding the duration of cases to understand how revenue is sustained over time. Statistical analysis shows that the average contested divorce in the United States takes roughly 1 year to reach a conclusion. However, for cases involving assets over $5 million, that timeline often doubles. During this period, the law firm acts as a financial sponge. Every motion filed, every discovery request sent, and every deposition scheduled adds to the billable total. In the professional legal world, this is known as the churn. The historical trend shows that firms that can maintain a high volume of active files, while simultaneously lengthening the duration of those files, see a nonlinear growth in annual revenue. Consider the step-by-step process of discovery, which is often the most profitable phase for a divorce firm. Discovery is the legal process where both parties must disclose every financial document they possess. In a modern 2026 context, this includes not just bank statements, but cryptocurrency wallet addresses, private equity holdings, and digital asset valuations. A firm will often assign a team of junior associates to comb through thousands of pages of documents. If an associate bills $300 per hour and spends 40 hours a week for 3 weeks on a single high-net-worth discovery phase, that single task generates $36,000 in revenue for the firm. This is before a single minute of trial time has occurred. This is why the industry has shifted away from quick settlements toward comprehensive discovery. The historical data suggests that the more thorough the discovery, the higher the ultimate revenue, regardless of whether that information actually changes the final settlement. Now let's dive into the psychology of the retainer and how it functions as an interest-free loan for the firm's operations. Historically, law firms required a small deposit. Today, the model has evolved into the evergreen retainer. Imagine if an attorney requires a $20,000 retainer from a client named Michael. As the attorney works, they draw down from that $20,000. However, the contract specifies that the moment the balance hits $5,000, Michael must replenish it back to the full $20,000. This ensures that the firm never works for free and maintains a constant stream of cash flow. From a business perspective, this is a masterpiece of financial engineering. It eliminates the risk of bad debt that plagues other service industries. Statistical records of law firm profitability consistently show that matrimonial firms using evergreen retainers have a significantly higher realization rate than those using traditional billing methods. We also have to discuss the concept of the battle of the experts. This is a secondary but vital revenue stream that bolsters the overall ecosystem. When a divorce attorney hires a forensic accountant to value a business, they are not just providing a service to the client. They are creating a complex narrative that requires more legal hours to defend or refute. If Firm A hires an expert for $15,000, Firm B must hire their own expert for an equivalent amount. The attorneys then spend dozens of hours deposing these experts. This historical trend of expert-driven litigation has pushed the average cost of a contested divorce in many U.S. states into the six-figure range. The data indicates that in states like New York and California, a fully litigated divorce with multiple experts can easily exceed $250,000 in total legal and professional fees. The evolution of marketing in this sector also tells a story of revenue growth. In the 1980s, lawyers were largely prohibited from aggressive advertising. After key Supreme Court decisions loosened these restrictions, the cost of client acquisition became a central metric. Today, in 2026, firms spend millions on search engine optimization and targeted social media ads. They aren't just looking for any client. They are looking for the profitable client. Data shows that firms focusing on high-conflict or complex asset niches have a 3 times higher profit margin than general family law firms. By using data-driven marketing, these firms can cherry-pick cases that have the highest potential for long-term billable hours. This selective intake process is a key reason why overall revenue in the sector continues to rise even when the number of marriages is declining. Furthermore, we must examine the impact of domestic relations orders and qualified domestic relations orders, commonly known as QDROs. These are specialized legal documents required to split retirement accounts. Because these require a high level of technical precision, firms often charge a separate, significant fee for their preparation, or they outsource them to specialists and add a management markup. This represents a micro-revenue stream that, when multiplied by thousands of cases, adds millions to the industry total. It is a perfect example of how the legal system has been fractalized, where every subtask of a divorce is turned into a distinct profit center. This brings us to a critical realization. The American divorce industry is not a monolith. It is a collection of high-efficiency financial silos. Each silo is designed to extract maximum value from the legal friction of a dissolving partnership. We have moved from a system of simple justice to a system of complex asset management. But there is a dark side to this revenue growth. As the cost of entry rises, a massive segment of the American population is being priced out of the traditional legal market, leading to a new phenomenon known as the pro se economy. This shift is creating a massive power vacuum in the legal world, and the way firms are pivoting to capture this low-value market is just as sophisticated as their high-end strategies. If you think the billable hour is the only way these firms make money, you are missing half the picture. In the next part, we are going to look at the secret world of success-based fee structures and the controversial rise of third-party litigation funding in divorce. We will explore how private equity is beginning to eye the matrimonial law sector as the next great frontier for investment. How does a law firm suddenly become an attractive asset for a hedge fund? And what happens to the average American when their divorce is literally traded on a secondary market? The transition from legal practice to a financial asset class is closer than you think. To understand the intrusion of high finance into the family court system, we must first look at the mechanics of litigation funding, a phenomenon that has historically transformed corporate law and is now aggressively penetrating the matrimonial sector. Litigation funding occurs when a third-party company provides the capital necessary to cover legal fees in exchange for a portion of the final settlement. While this was once considered a violation of ancient legal doctrines like champerty and maintenance, the 2026 legal landscape has shifted toward a more permissive stance, viewing these arrangements as a way to level the playing field for the non-moneyed spouse. From a revenue perspective, this is a game changer. Historically, if a spouse had no access to the marital accounts, the attorney took on a massive risk of non-payment. This often forced attorneys to settle early to ensure they could collect their fees. However, with the entry of specialized divorce funding firms, that risk is offloaded. Imagine a character named David. David is married to a high-earning executive with assets hidden in offshore trusts and private equity ventures. David has zero liquidity. In the past, he might have struggled to find a top-tier firm willing to take his case. But in 2026, a litigation funder evaluates the marital estate, sees a potential $20 million settlement, and cuts a check for $500,000 to a premier law firm. This creates a significant historical trend: the professionalization of the risk. The law firm now has a guaranteed revenue stream regardless of David's immediate bank balance. Because the firm is being paid by a funder with deep pockets, they have the financial runway to engage in a 3-year war of attrition. This significantly increases the total billable hours per case. Case studies from recent years show that when a case is backed by third-party funding, the legal fees tend to be 30 to 50% higher than in self-funded cases. The funder isn't just a passive observer. They are a sophisticated entity that understands the potential outcomes and treats the divorce as a high-yield investment vehicle. This brings us to the rise of private equity's interest in the legal sector. For decades, the American Bar Association's Rule 5.4 prohibited non-lawyers from owning law firms. This was intended to ensure that a lawyer's primary duty was to their client, not a shareholder. However, several states, starting with Arizona and Utah, have experimented with loosening these rules to allow for alternative business structures. This has opened the door for private equity firms to begin rolling up family law practices. In a roll-up, a private equity group buys 20 or 30 smaller, independent divorce firms and consolidates them under a single corporate umbrella. The goal is to apply corporate efficiency to the chaos of family law. They implement standardized billing software, aggressive digital marketing funnels, and centralized intake departments. The historical data from these consolidated firms suggests a massive increase in revenue per attorney. By treating the law firm like a manufacturing plant, these corporations can squeeze out every possible billable second. For the partners who sell their firms, it is a way to monetize their book of business for a multi-million-dollar payout. For the consumers, it often means they are dealing with a high-volume machine rather than a personal counselor. Let us look at the step-by-step process of how a private equity-backed firm maximizes revenue during the intake phase. When a prospective client calls, they aren't talking to a lawyer. They are talking to a trained sales representative using a psychological script. This representative is looking for specific financial triggers: ownership of a business, multiple real estate holdings, or high-income potential. Once a high-value lead is identified, they are funneled to a senior partner who specializes in closing the retainer. The revenue is front-loaded to ensure the firm recovers its acquisition cost for that client as quickly as possible. This is a far cry from the old-fashioned lawyer in a small-town model. It is a data-driven, conversion-optimized revenue engine. There is also the emergence of the shadow revenue, found in the referral networks between divorce attorneys and other financial professionals. In many jurisdictions, an attorney cannot take a direct kickback for referring a client to a mortgage broker or a financial planner. However, they can participate in mutual referral agreements. Historically, this has created an ecosystem where the divorce attorney sits at the center of a wealth transfer web. When an attorney handles a divorce for a client like Jennifer, who has a $3 million retirement portfolio, the attorney refers Jennifer to a specific wealth manager to handle the post-divorce rollover. In return, that wealth manager refers their high-net-worth clients who are contemplating divorce back to that attorney. While no money changes hands directly between the professionals, the lifetime value of that referral relationship is worth millions in revenue over a decade. This is why you see the most successful divorce firms hosting elaborate networking events for forensic accountants, real estate agents, and luxury car dealers. They are building a moat around their revenue sources. In 2026, the elite divorce attorney isn't just a litigator. They are a high-stakes power broker in the local economy. Another fascinating statistical trend is the contempt revenue cycle. In family law, a judge's order is only as good as its enforcement. When one party fails to pay alimony or refuses to follow a visitation schedule, a motion for contempt is filed. Historically, these motions are the bread and butter of recurring revenue. Unlike the initial divorce, which has a beginning and an end, contempt and enforcement actions can continue for 18 years, until the children reach the age of majority. Firms that specialize in high-conflict enforcement have discovered that they can generate a steady, predictable revenue stream that is largely immune to the economic cycle. Even in a recession, people will fight over child support payments, and every one of those fights is a billable event. We must also consider the premium for privacy. In the age of digital footprints and social media, high-profile individuals are willing to pay an enormous premium for private judging or collaborative divorce models that keep their dirty laundry out of the public record. In many U.S. states, parties can agree to hire a retired judge to hear their case in a private law office rather than a public courthouse. The parties pay for the judge's time, the court reporter's time, and their own attorney's time. From a revenue standpoint, this is the first-class cabin of divorce. The hourly rates in these private proceedings are often 30 to 50% higher than in standard litigation because of the exclusivity and discretion being sold. As we examine these various streams, from litigation funding to private equity roll-ups and private judging, a clear picture emerges. The U.S. divorce industry has moved beyond being a service and into being a sophisticated financial marketplace. The revenue isn't just coming from the law, it's coming from the friction of separation. And in a country with high asset values and high personal conflict, that friction is a commodity that is increasingly being traded and leveraged by outside interests. But what happens when the technology itself becomes the lawyer? We are starting to see the first wave of artificial intelligence models that can draft motions, predict judicial outcomes with 85% accuracy, and automate the entire discovery process. You might think this would destroy attorney revenue by making things too efficient. But the historical trend suggests the opposite. When the grunt work becomes cheaper, the strategy becomes more expensive. In the next part, we will dive into the AI revenue paradox and look at how the top 5% of law firms are using machine learning to actually increase their bills while doing less manual labor. How can an algorithm make a divorce more expensive? The answer lies in the predictive litigation models that are changing the way lawyers think about every single case. The integration of artificial intelligence into the American legal landscape in 2026 has created a fascinating economic phenomenon known as the efficiency premium. Historically, technology is supposed to drive costs down for the consumer, but in the high-stakes world of matrimonial law, we are seeing the opposite trend. Top-tier firms are leveraging large language models and predictive analytics to compress the time spent on administrative tasks, yet they are maintaining or even increasing their total revenue through a shift in billing philosophy. Instead of billing for the hour of typing, they are billing for the microsecond of insight. Imagine a specialized firm in 2026 called Nexus Family Law. In the past, a team of paralegals would spend 3 weeks analyzing 5 years of bank statements for a client named Robert, who owns a chain of fitness centers. They were looking for inconsistencies or hidden transfers. This was a massive revenue driver under the old billable hour model. Today, Nexus uses an AI-driven forensic tool that ingests those same statements and identifies anomalies in 45 seconds. On paper, the billable hours for that task dropped from 100 to 0. However, the firm now charges a technology fee or a value-based flat fee for the forensic insight report. Because the AI found a hidden offshore account that a human might have missed, the firm can justify a higher success-based strategy fee. The historical trend here is the transition from labor-intensive billing to intellectual property-intensive billing. This brings us to the concept of predictive litigation. Law firms are now using massive datasets of past judicial rulings in specific counties, such as Orange County, California, or Wake County, North Carolina, to predict the exact percentage chance of a specific judge granting a specific motion. If the data shows that Judge Smith has an 82% historical trend of awarding primary custody to the higher-earning spouse when certain psychological triggers are met, the attorney can advise the client with unprecedented precision. This doesn't make the case shorter, it makes it more tactical. Step by step, the attorney uses this data to decide which battles are worth fighting. If the algorithm says a motion for exclusive use of the marital residence has only a 12% chance of success, but filing it will cost the opposing side $20,000 in legal fees to defend, the firm might still recommend filing it as a strategic leverage play. This is where the revenue multiplies. We are seeing a historical example of weaponized data where the goal is not just to win, but to outfinance the opposition. The more data a firm has, the more moves they can play on the board. And every move is a billable event, even if the algorithm predicted the outcome from the start. We must also analyze the emergence of the AI-enhanced discovery phase. In 2026, discovery isn't just about papers. It is about metadata, deleted messages, and pattern recognition in lifestyle spending. High-end firms now employ data architects alongside their legal teams. When a client like Sarah suspects her spouse is underreporting income from a side business, the AI doesn't just look at tax returns. It scrapes public social media data, analyzes geotags from photos over the last 3 years, and cross-references them with known luxury travel costs. This level of investigation used to be reserved for federal agencies, but it is now a standard premium service in the divorce industry. The revenue generated from these digital forensic packages is immense. A firm might charge a $30,000 flat fee for a deep-dive digital audit. While the software does the work, the human attorney must then spend dozens of hours translating that data into admissible evidence for a deposition. The technology hasn't replaced the lawyer. It has simply provided the lawyer with more ammunition to fire, extending the length of the conflict and the depth of the bill. Furthermore, the rise of AI has led to the growth of the tiered service model. On the bottom tier, you have the completely automated DIY divorce platforms. These handle simple, uncontested cases for a few $100s. Historically, these cases were never profitable for big firms anyway, so they are happy to let the software take them. This has cleared the docket for the middle and high-tier firms to focus exclusively on high-conflict litigation. Consider a case study from a mid-sized firm in Texas. By offloading their low-value cases to an automated subsidiary, they were able to increase their average revenue per case by 65% in just 2 years. They stopped being a general practice and started being a litigation house. This is the bifurcation of the legal market. The data shows that the middle ground, the moderately priced family lawyer, is disappearing. You are either paying for a bot, or you are paying for a high-powered team using a bot to maximize their strategic advantage. We also see a fascinating shift in the marketing of these services. In 2026, firms aren't just advertising their wins, they are advertising their tech stack. You will see historical trends of firms branding themselves as data-driven divorce or algorithmic advocates. They are targeting a tech-savvy US public that trusts data more than gut feeling. For a client who works in Silicon Valley or the Research Triangle, the idea that their lawyer is using a proprietary algorithm to protect their equity is a massive selling point. This allows these firms to charge what is known as a tech premium on top of their standard hourly rates. There is another layer to this. the automate to litigate cycle. When a law firm can draft a motion for summary judgment in 6 minutes using AI, they are more likely to file more motions. Historically, an attorney might have hesitated to file a marginal motion because the cost to the client would be too high relative to the benefit. But if the labor cost to the firm is near zero, and they can still bill a fraction of the traditional cost, the volume of filings increases. This floods the court system and forces the opposing counsel to respond, which in turn generates more revenue for both sides. It is a self-sustaining cycle of billable activity facilitated by the very technology that was supposed to make the law more accessible. As we look at the statistical landscape of 2026, we also see the emergence of virtual reality mediations. To save on travel costs and physical office overhead, firms are charging premium fees for high security, encrypted VR environments where parties can meet in a neutral, simulated space. These environments are designed by psychological experts to lower defenses or, in some tactical scenarios, to maintain a position of power. The setup and management of these virtual legal spaces represent a brand new revenue category that didn't exist a decade ago. It is a perfect example of how the legal industry finds ways to monetize the physical and emotional distance between two parties. The data is clear. The revenue of the American divorce attorney is not just surviving the AI revolution. It is being supercharged by it. By automating the mundane, the industry has freed up its most expensive assets, the senior partners, to focus on the psychological and financial warfare that drives the largest settlements. But as the cost of this tech-heavy litigation climbs, we have to ask, who is actually winning? If the lawyers are using AI to fight other lawyers using AI, does the client ever see a reduction in the total bill? The reality of the 2026 market suggests that the total cost of a divorce is reaching a breaking point for the American middle class. This is leading to a massive underground shift in how people handle their separations outside of the traditional court system. In the next part, we are going to look at the rise of the shadow legal market, private mediation empires that operate entirely behind closed doors, where the revenue isn't tracked by the government, and the rules of engagement are written by the highest bidder. How are these private forums siphoning billions away from the public courts, and why are the biggest law firms in the country secretly fighting to control them? The move toward private justice is the most controversial shift in legal history, and it's happening right now. The transition toward private justice in 2026 is not merely a change in venue. It is a fundamental restructuring of the legal revenue model in the United States. Historically, the public court system served as the primary theater for matrimonial disputes, but the statistical data shows a massive migration toward private arbitration and high-stakes mediation. This move is driven by a desire for total confidentiality, but from a business perspective, it has allowed law firms to capture a larger percentage of the client's total spend by cutting out the inefficiencies of the state-run judiciary. In a public court, you are at the mercy of a judge's backlog, which can stall a case for months. In the private sector, time is literally money, and the speed of the private system allows for a higher velocity of billable events. Imagine a high-net-worth individual named Christopher, a tech founder in Austin, Texas. Christopher's estate is valued at over $50 million, and much of that value is tied up in intellectual property and pre-IPO stock. If Christopher goes through a public divorce, his company's valuation, his cap table, and his personal spending habits become a matter of public record. To avoid this, he and his spouse agree to move their case to a private forum. This is where the revenue explosion occurs. Instead of paying for just their attorneys, the parties now pay for a private judge, a private court reporter, and a private venue. In 2026, the historical trend shows that these private judicial officers, often retired Supreme Court justices from their respective states, can command fees ranging from $1,000 to $3,000 per hour. The law firms representing these individuals don't lose revenue in this faster system. They simply densify it. In a traditional court setting, an attorney might spend 4 hours waiting in a hallway for a 15-minute hearing. That is dead time that is difficult to bill at the highest rates. In the private justice model, every minute is scheduled and productive. A firm can bill for 6 hours of intense, high-level negotiation in a single day. And because the stakes are so high and the environment is so controlled, they can justify a premium rate. Case studies of elite firms in New York and Florida show that revenue per partner is often 20% higher in firms that exclusively handle private arbitration compared to those that litigate in public courtrooms. Step by step, the private justice model creates a new hierarchy of billing. First, there is the forum selection fee. Attorneys spend hours and therefore bill thousands just negotiating which private judge will hear the case. They look at the judge's historical trends regarding asset division and alimony duration. This is followed by the appointment of experts. In a private setting, the experts are often given more latitude to perform deep dive audits, leading to longer, more detailed reports that require more billable hours to analyze. Because there is no public judge to tell them to move faster, the parties can spend as much as they want on the pursuit of every single penny. This is the luxury tier of the divorce industry, where the revenue is limited only by the size of the marital estate. We must also analyze the emergence of the mediation industrial complex. Mediation was originally designed as a low-cost alternative to litigation, but as it has professionalized, it has become its own massive revenue center. By 2026, many U.S. jurisdictions have made mediation mandatory before a trial can even be scheduled. This has created a captive market. Firms have responded by creating dedicated mediation departments. These are not staffed by junior associates, but by senior partners who bill at the top of the scale. The data suggests that mediation, while often successful at avoiding trial, does not necessarily lower the total legal fees. Instead, the money that would have been spent on trial preparation is simply shifted to mediation preparation. Consider a scenario where a couple named Elena and Marcus are going through a mid-market divorce with $2 million in assets. They are ordered into mandatory mediation. Their attorneys each spend 20 hours preparing a mediation brief, a document that outlines their legal position. During the mediation, which lasts 2 full days, 2 attorneys and 1 mediator are all billing simultaneously. If the average rate is $400 per hour, the mediation alone can generate over $16,000 in revenue for the legal ecosystem in just 48 hours. Historically, this is one of the most efficient revenue extraction points in the entire process. Furthermore, we are seeing the rise of the specialized settlement architect. This is a relatively new role in the 2026 legal market. These are attorneys or financial professionals who do nothing but design the complex tax and structural frameworks for high-value settlements. They operate as subconsultants within the divorce process. By framing their work as a way to save the client millions in future taxes, they can charge based on the value they create rather than just the time they spend. This value-based billing is a significant departure from the historical billable hour and represents a new frontier for law firm profitability. If a settlement architect saves a client $500,000 in capital gains taxes through a clever asset swap, they might bill a flat $50,000 fee for that specific piece of work. The shift toward private justice also has a significant impact on the insurance and liability side of the legal business. Because private proceedings are confidential, the risk of a public malpractice suit or a reputation-damaging ruling is minimized. This lower risk profile allows firms to be more aggressive in their legal theories, which in turn leads to more hours spent on research and development of new tactics. It is a feedback loop where the lack of public oversight encourages more complex, and therefore more expensive legal maneuvers. Statistical trends in 2026 show that the average number of pages in a private settlement agreement has doubled over the last decade, reflecting the increased complexity and the increased hours required to draft them. This brings us to the shadow market of pre-divorce planning. In the elite tiers of American wealth, the revenue starts flowing long before a divorce is even filed. Attorneys are increasingly being hired to perform matrimonial audits for individuals who are still happily married but want to understand their potential exposure. This is a preventative revenue stream. The attorney reviews prenuptial agreements, analyzes the commingling of separate property, and suggests structural changes to business holdings to protect assets in the event of a future dissolution. How are the states reacting to this loss of high-value cases and the revenue they generate through filing fees? And more importantly, what happens when the public system starts to look like a completely different world than the private one? In the next part, we are going to explore the economics of the urban versus rural divide. We will look at how a divorce attorney in a city like Manhattan or San Francisco generates more revenue from 5 cases than a rural attorney does from 50. We will break down the exact math of the geography of alimony and show you how where you live is the single biggest factor in how much your attorney makes. To understand why geography is destiny in the American legal market, we must look at the divergence of the revenue per case metric across the diverse landscapes of the United States. In 2026, the gap between urban and rural divorce attorney revenues has reached a historic peak. This is not just a matter of different hourly rates. It is a fundamental difference in the types of assets being litigated and the statutory frameworks that govern them. We are seeing a historical trend where a family law practitioner in a rural county in the Midwest might handle 60 cases a year to generate a gross revenue of $300,000, while an attorney in a specialized boutique in downtown Seattle or Miami can generate $2 million from just 6 high-stakes files. Consider the case of an attorney named Thomas, practicing in a rural community in central Nebraska. In 2026, Thomas serves a population where the primary assets in a divorce are typically a primary residence, agricultural land, and perhaps some heavy machinery. The legal process here is often dictated by traditional equitable distribution, but the absolute dollar value of the marital estate is lower. Because the local economy cannot support a $500 hourly rate, Thomas bills at $175 per hour. His revenue is volume dependent. He must process files quickly, meaning he spends less time on deep dive discovery or complex financial modeling. This creates a low-margin, high-volume business model that is highly susceptible to local economic downturns. Now, contrast this with a character named Isabella, who operates a firm in the zip codes of Greenwich, Connecticut. Isabella's overhead is significantly higher, but her revenue potential is decoupled from the volume of her work. In Isabella's world, the marital estate isn't just a house. It is a web of deferred compensation, restricted stock units, carried interest in hedge funds, and multi-state real estate holdings. Because the assets are complex, the legal maneuvers required to untangle them are extensive. Isabella bills $750 per hour, and her clients are not sensitive to that price because they are protecting $40 million in assets. In this high-density wealth environment, the revenue generated by a single deposition can exceed the total fee Thomas earns for an entire 3-month divorce proceeding. The math of the geography of alimony further deepens this divide. In the United States, alimony or spousal support is governed by state-specific statutes that vary wildly. Some states have rigid formulas, while others, like Virginia or Florida, have historically allowed for more judicial discretion. This discretion is a massive revenue driver. When the outcome of a support award is predictable, there is less to argue about, and therefore fewer billable hours. But in jurisdictions where an attorney can argue over the lifestyle of the parties, or the future earning capacity of a spouse, the billable hours explode. A firm in a high-discretion state can spend 40 hours of billable time just creating a lifestyle analysis report that justifies a higher monthly support payment. This is why revenue consistently clusters in states with complex, discretionary support laws. Step by step, we can see how the cost of living in these urban centers creates a self-fulfilling prophecy of higher legal revenue. Because it costs more for the client to live, the alimony stakes are higher. Because the alimony stakes are higher, the litigation is more intense. Because the litigation is more intense, the attorneys can justify higher rates and more staff. This has led to the emergence of what economists call the legal superhubs. These are cities where the concentration of wealth and specialized legal talent has created an island of hyperinflated legal revenue that bears no resemblance to the national average. Statistics from 2026 show that the top 5% of matrimonial attorneys in these hubs now account for nearly 35% of the total industry revenue in the entire country. Let us look at a case study involving the valuation of professional degrees or celebrity status, which varies by geography. Historically, some states like New York considered a professional degree earned during the marriage to be a marital asset that could be valued and divided. While many of these laws have been refined, the argument over enhanced earning capacity remains a goldmine for attorneys in talent-heavy cities like Los Angeles or Nashville. If an attorney is representing the spouse of a rising tech executive or a media personality, they will hire vocational experts to project the next 30 years of that person's career. The billable time spent debating whether a specific career milestone is a result of marital effort or individual talent represents millions of dollars in annual revenue that simply does not exist in rural markets. The urban-rural divide is also reflected in the technology gap. As we discussed in earlier parts, high-end firms are using expensive AI and forensic software. Isabella in Greenwich can afford a $50,000 annual subscription to a predictive analytics suite because she can amortize that cost over her multi-million-dollar cases. Thomas in Nebraska cannot justify that expense for a case involving a $50,401,000. This means the urban firms are becoming more efficient and more lethal in their litigation tactics, further widening the gap in potential outcomes for their clients and the revenue they can command. This is creating a two-tiered system of American justice where the revenue generated is a direct reflection of the technological arms race. Furthermore, we must consider the impact of the 2026 remote work revolution on these revenues. Historically, you had to hire an attorney in your local county. However, with the rise of virtual hearings and digital filing, high-end urban firms are starting to poach high-asset cases from neighboring rural counties. This is a new historical trend, the regional revenue vacuum. A wealthy business owner in a rural part of Pennsylvania might now hire a top-tier firm in Philadelphia to handle their case via Zoom. This siphons the high-value revenue out of the local community and concentrates it in the urban hubs, leaving rural practitioners with only the lowest margin cases. The data suggests that local rural firms are seeing a 5 to 10% decline in annual revenue as their wealthiest clients migrate to city-based legal brands. We also see this geographic disparity in the specialized marketing spend. A firm in San Francisco might pay $300 per click for the search term divorce attorney for business owners. They can afford this because the potential revenue from one such client is astronomical. A rural attorney might only pay $2 per click for the term local divorce lawyer. This digital gatekeeping ensures that the most profitable cases are funneled into the most expensive firms, creating a feedback loop that sustains high revenues in the cities regardless of the actual divorce rate. But the most shocking part of this geographic math isn't just the difference in what the lawyers make. It is the difference in how they are paid. In urban hubs, the use of credit-based litigation and third-party funding is common, allowing firms to keep billing even when the client runs out of cash. In rural areas, the industry still operates largely on a cash-upfront basis. This means that in the cities, the revenue is not just higher, it is more resilient. As we look toward the next chapter of this deep dive, we have to address a growing movement that threatens this entire revenue structure. A new wave of legislative reform is sweeping through several key states, aiming to standardize alimony and asset division to the point where an attorney's discretion is almost entirely removed. If the law becomes a simple math equation that anyone can run on a smartphone, what happens to the $13 billion in billable hours? In the next part, we are going to look at the legislative threat, the specific bills being introduced in 2026 that could slash legal revenues by 40% overnight. We will examine the lobbying efforts of the American Bar Association to stop these reforms and the secret war between tech companies and law firms over who gets to control the future of legal math. The fight for the billable hour is about to get very ugly. The legislative landscape of 2026 is currently the site of a high-stakes standoff that could fundamentally dismantle the revenue models we have analyzed so far. At the heart of this conflict is the push for alimony standardization and presumptive asset division. Historically, the vagueness of family law has been the primary engine for billable hours. When the law is subjective, attorneys are paid to argue. When the law is objective, they are replaced by calculators. We are seeing a historical trend where state legislatures in places like Florida, Ohio, and even California are debating bills that would replace judicial discretion with rigid, math-based formulas. To understand the economic impact, imagine a character named Mark, a corporate executive in Miami. Under the old discretionary system, Mark and his spouse might spend 18 months litigating what constitutes a fair amount of alimony. Their attorneys would bill for hundreds of hours of research, depositions of lifestyle experts, and multiple hearings. The potential outcomes were wide, creating a high-stakes environment that justified massive fees. However, under the proposed 2026 Alimony Formula Act, the alimony is calculated strictly based on the duration of the marriage and the income delta between the parties. There is no room for argument. In this scenario, the legal work that previously took 200 hours is reduced to a 5-minute data entry task. For the law firm, this represents a revenue collapse of over 90% on that specific case. This is why the lobbying efforts of state bar associations have reached a fever pitch. In 2026, the historical data shows that legal trade groups are spending record amounts on campaign contributions and legislative outreach to prevent these formulas from becoming law. They argue that every family is unique, and that a one-size-fits-all math equation cannot deliver true justice. From a business perspective, however, they are defending the complexity of the law because complexity is the product they sell. If the law becomes simple, the product loses its value. Simultaneously, we are seeing the rise of the secret war between big tech and big law. Companies like Google and Microsoft, along with specialized legal tech startups, are developing consumer-facing platforms that can predict settlement ranges with 95% accuracy, based on thousands of historical data points. These companies are pushing for open access laws that would force courts to release their sentencing and settlement data in machine-readable formats. Law firms are fighting this tooth and nail. They understand that if a consumer like a character named Linda can go to a website, pay a $50 subscription, and see that 98% of people in her exact financial situation receive a specific settlement, she is far less likely to pay a lawyer a $20,000 retainer to find that same information. This technological threat has forced firms into a tactical pivot. Since they can no longer purely sell information or predictability, they are shifting their marketing to emphasize the emotional and strategic war. They are selling the idea of the legal advocate as a shield or a sword, rather than a counselor. This has led to a historical increase in high-conflict marketing. If the math is fixed, the only way to increase revenue is to increase the number of filings or the duration of the conflict through procedural obstacles. We are seeing a trend where firms in formula-based states are specializing in the exceptions to the rules. They bill thousands of hours searching for a loophole in the formula, turning a simple math problem back into a complex legal dispute. Step by step, the industry is also responding by diversifying its revenue streams through ancillary businesses. In 2026, you will see law firms that own or have significant partnerships with real estate brokerages, counseling centers, and financial planning firms. The globalization of American wealth has birthed a new echelon of legal professionals, the international matrimonial elite. In 2026, the historical trend of high-net-worth individuals diversifying their assets across borders has created a jurisdictional nightmare that serves as a goldmine for specialized law firms. When a marital estate expands beyond the borders of the United States, the standard billable hour model is often supplemented by massive project-based fees and the necessity of managing a global network of sub-counsel. This is the world of the offshore audit, the Hague Convention disputes, and the chase for digital assets buried in servers located in neutral jurisdictions. Imagine a character named Julian, a venture capitalist based in Palo Alto. Julian is going through a divorce in 2026. While his primary residence is in California, his wealth is a complex tapestry including a technology holding company in Ireland, a series of trust accounts in the Cook Islands, and a luxury development project in Dubai. For Julian's spouse, the legal battle isn't just about filing paperwork in a Santa Clara County court. It is a multi-front war that requires a legal team capable of navigating the laws of 4 different countries simultaneously. In this scenario, the lead U.S. attorney acts as the general of a global army. The revenue generated from a case like Julian's is staggering. Historical trends show that international divorce cases carry a legal fee premium of 300 to 500% compared to domestic cases of similar asset value. This is due to the sheer volume of discovery required. Step by step, the U.S. firm must initiate letters rogatory, which are formal requests from a U.S. court to a foreign court for judicial assistance. This process alone can take 6 to 12 months and cost upwards of $50,000 in legal drafting and translation fees. Because every country has different privacy laws regarding banking, the attorney must bill hundreds of hours just to determine if a specific asset can even be legally identified, let alone divided. We must also analyze the strategic use of forum shopping as a revenue driver. Forum shopping is the practice of attempting to have a case heard in the jurisdiction that will provide the most favorable financial outcome. For an attorney, this is a high-level chess game. If a couple has residences in both London and New York, the difference in the final settlement can be tens of millions of dollars due to how those cities handle lifetime alimony versus fixed-term support. Attorneys bill heavily for the initial jurisdictional battle. Statistical data from 2026 suggests that elite firms spend an average of 80 to 100 hours on the jurisdictional phase alone before the substance of the divorce is even addressed. Consider a case study of a high-profile dissolution where one party filed in England, known as the divorce capital of the world for its generous awards to the non-moneyed spouse, while the other filed in a U.S. state with stricter limits on spousal support. The legal fees spent just to decide where the divorce would happen exceeded $1 million. This is what we call jurisdictional revenue. It is money earned by lawyers fighting about where they are going to fight. In the high-stakes world of international finance, the venue is often more important than the evidence, and clients are willing to pay a premium to secure the home court advantage. Now, let us look at the specialized role of the international asset tracer. In 2026, this is a distinct sub-niche of the divorce industry. These are firms that combine legal expertise with forensic data science and boots-on-the-ground intelligence. When a spouse suspects that millions have been moved into a shell company in a jurisdiction like Panama or the Seychelles, they don't just hire a lawyer, they hire a hunter. The revenue model for asset tracing often involves a high base retainer plus a percentage of the recovered assets, structured as a consultancy fee to navigate state bar regulations. The process involves mapping out layers of corporate ownership. Imagine if a law firm finds that a husband's business is owned by a holding company in Delaware, which is owned by a trust in Nevis, which is managed by a director in Singapore. To untangle this, the U.S. attorney must hire local counsel in each of those jurisdictions. The U.S. firm then adds a management markup to these international fees. This creates a cascading revenue effect where the lead firm becomes a hub for a global fee-sharing network. Historical examples of these international chases show that for every $1 hidden, it can cost 30 cents in legal fees to find it. For a $50 million hidden account, that represents $15 million in legal and forensic revenue. Furthermore, the rise of decentralized finance and cryptocurrency in 2026 has added a digital layer to this international map. Historical trends indicate that roughly 20% of high-value divorces now involve a significant dispute over digital assets. Because crypto is borderless, the legal revenue is generated by the complexity of the on-chain investigation. Attorneys now bill for the time spent working with specialized blockchain forensic firms to track movements from cold wallets to hot exchanges. This work is highly technical and commands the highest hourly rates in the industry. We are seeing cases where a firm bills $10,000 a day just for the monitoring of a specific crypto wallet address during the pendency of a case. The Hague Convention on the Civil Aspects of International Child Abduction also represents a significant, though somber, revenue stream. When one parent moves a child to another country without consent during a divorce, the legal response is immediate and incredibly expensive. These are high-priority, high-stress cases that require 24-hour legal teams and immediate coordination with federal authorities and the State Department. The revenue from a single Hague case can range from $75,000 to over $200,000 because of the expedited nature of the proceedings. Historically, the firms that specialize in this niche are among the highest earners per partner because they are selling a service, the return of a child, where the client is virtually price insensitive. As we look at the statistical growth of this international sector, we see that it is largely immune to the domestic legislative reforms we discussed in Part 7. While a state legislature can simplify alimony in Ohio, they have no power over how a trust is handled in the Isle of Man. This makes international matrimonial law the ultimate moat for high-end revenue. The attorneys who can navigate these waters are not just lawyers. They are international financial architects. However, this global expansion has led to an interesting new development: the rise of the international divorce insurance market. In 2026, we are seeing the first historical trends of wealthy individuals taking out insurance policies specifically to cover the legal fees of a potential cross-border divorce. This allows law firms to bill with absolute confidence, knowing that an insurance carrier is backing the litigation. This further stabilizes the revenue of the elite firms and allows them to take even more aggressive stances in global asset discovery. This brings us to a critical intersection. As the money becomes more global and the technology becomes more forensic, the divorce industry is moving toward a state of total transparency for the wealthy. But this transparency comes at a price that only the top 1% can afford. We are witnessing the birth of a two-speed legal system where the rich use global experts to find every penny, while the rest of the population is funneled into automated, math-based systems. But what if the money isn't just hidden in a bank? What if the biggest asset in a 2026 divorce isn't a house, a stock, or even a cryptocurrency? In the next part, we are going to dive into the most controversial and fastest-growing revenue stream in the entire legal world: the valuation of personal data and social influence. We will look at how attorneys are now billing for the divorce of a digital brand, and how a YouTuber's subscriber count or an influencer's engagement rate is being appraised as a multi-million-dollar marital asset. How do you divide a like? And who gets the revenue from a viral video made during the marriage? The battle over the digital soul is the new frontier of legal revenue. As we transition into the digital-first economy of 2026, the traditional definitions of marital property are undergoing a radical transformation. In the past, attorneys looked for physical real estate or brokerage accounts. Today, the most valuable asset in the room might be an intangible network of digital influence. This has birthed a specialized sector of legal revenue: intellectual property valuation and domestic relations. The historical trend shows that as the creator economy has matured into a multi-billion-dollar industry, the divorce attorney's role has shifted from simple litigator to a high-stakes brand appraiser. Imagine a character named Chloe, a lifestyle influencer with 4 million subscribers. Chloe married her spouse, a videographer, in 2020 when her channel was just a hobby. By 2026, the channel generates $3 million in annual ad revenue and sponsorship deals. In a divorce, the legal question is no longer just about who gets the house. It is about the valuation of the Chloe brand. Is the growth of that brand a marital asset? Because the videographer spouse contributed to the production and strategy during the marriage, the law in many U.S. states considers the appreciation of that digital asset to be divisible. This creates a massive billable opportunity for law firms. To value a digital brand, an attorney must hire a new breed of expert, the social media forensic auditor. These experts don't just look at tax returns, they analyze engagement rates, the longevity of audience demographics, and the future contract value of existing brand deals. A firm might bill 200 hours just to establish the baseline value of a YouTube channel or a TikTok presence. The revenue is generated through the sheer complexity of predicting the future income of a person whose relevance is tied to an algorithm. Case studies from 2025 and 2026 show that the cost of valuing a digital brand often exceeds $100,000 in professional fees before the case even reaches a courtroom. The step-by-step process of dividing a digital soul involves a meticulous breakdown of what is known as personal goodwill versus professional goodwill. Historically, personal goodwill, the value tied specifically to a person's face and personality, is not a divisible marital asset. However, professional goodwill, the business systems, the editing workflows, the database of sponsors, and the intellectual property of the content is divisible. Attorneys generate significant revenue by engaging in a battle of the experts over where Chloe the person ends and Chloe the business begins. Every minute of a video, every sponsored post, and every line of merchandise is scrutinized to determine what percentage of the revenue was generated by the marital effort versus the individual talent. Furthermore, we must look at the revenue implications of the post-divorce content rights. In 2026, we are seeing the emergence of digital royalty splits. Historically, when a couple divorced, they sold the house and split the profit. You cannot easily sell a personal brand. Instead, attorneys are drafting complex, multi-year settlement agreements where one spouse receives a percentage of the ad revenue from all videos created during the marriage. This turns the divorce attorney into a long-term business manager. The firm generates recurring revenue by overseeing the accounting of these digital royalties for years after the final decree is signed. This is a historical shift from a one-time fee model to a long-term asset management model. Now, consider the high-stakes world of the data privacy breach within a divorce. In 2026, personal data is a weapon. As part of the discovery process, attorneys now demand access to private cloud storage, direct messages, and even the metadata of deleted content. This has led to the rise of the digital custodian, a legal professional who specializes in the ethical handling and filtering of highly sensitive personal data during litigation. If an attorney finds data that could damage a person's public brand, the settlement value of the case changes instantly. The revenue generated from these high-tech phishing expeditions is immense, as it requires a combination of elite hacking forensics and legal maneuvering to ensure the data is admissible. We also have to analyze the economic impact of the morality clause in modern settlements. For a digital creator, their revenue is tied to their reputation. If a divorce becomes messy and public, the brand value can vanish overnight. Consequently, 2026 has seen a surge in the use of high-priced non-disparagement agreements. Attorneys are billing $20,000 to $30,000 just to draft clauses that govern what each party can say on a live stream or a podcast after the split. This is effectively the monetization of silence. The data suggests that for high-profile creators, the cost of protecting the brand's reputation during a divorce is often the largest single-line item on the legal bill. Step by step, the industry is also adapting to the valuation of virtual real estate and gaming assets. Imagine a couple that has spent the last 5 years building a digital empire in a metaverse platform, owning virtual land that has appreciated in value alongside physical real estate. In 2026, this is not a fringe case. It is a statistical reality for a growing segment of the U.S. public. Attorneys must now understand the tax implications of transferring virtual assets and the jurisdictional hurdles of enforcing a court order on a decentralized platform. The billable hours spent educating judges on what a digital plot of land is and how it generates revenue are adding millions to the annual industry totals. This leads to a fascinating historical anomaly: the decoupling of revenue from the divorce rate. Even if fewer people are getting married or divorced, the value of the assets being litigated is expanding into new dimensions. The move from the physical to the digital means that there is more to fight over, more to value, and more to protect. The 2026 divorce attorney is a hybrid of a lawyer, a tech agent, and a brand strategist. This diversification of the asset pool ensures that the revenue of the top 5% of firms continues to climb regardless of the broader social trends. We are also seeing the professionalization of the influencer divorce management firm. These are boutique agencies that handle the legal, PR, and financial aspects of a high-profile digital split. They charge a percentage of the total brand value as a management fee. This represents a total departure from the traditional hourly rate and shows how the legal world is adopting the compensation structures of Hollywood and Silicon Valley. By 2026, the revenue generated by these specialized boutiques has outpaced traditional family law firms in major hubs like Los Angeles and Austin. But as the battle moves into the digital cloud, we are left with a haunting question. If your brand, your data, and your social influence are all marital assets, do you ever truly own yourself after a divorce? The legal system is creating a world where your future earnings are perpetually tethered to your past relationships through the math of digital royalties. In the final part of this masterclass, we are going to look at the 2030 horizon. We will synthesize everything we have learned about AI, global asset wars, and digital souls to predict the final evolution of the American divorce attorney. We are going to look at the emergence of the automated arbitrator and the potential for a world where divorce is instantaneous, algorithmically determined, and entirely handled by the state. Will the $13 billion engine finally run out of fuel? Or is the industry about to find its biggest revenue stream yet in the world of genetic and biological assets? The final chapter of the statistical history of divorce is the most shocking of all. The intersection of biotechnology and family law represents the absolute frontier of legal revenue as we gaze toward the year 2030. Historically, the division of property was limited to things you could touch or bank accounts you could quantify. In 2026, we are already seeing the first wave of litigation involving biological and genetic material, a sector that is projected to grow into a multi-billion-dollar sub-niche. This is not science fiction. It is a direct consequence of the massive investment Americans have made in assisted reproductive technology and personalized medicine over the last 2 decades. For the specialized divorce attorney, this represents the ultimate high-value asset because it is literally priceless, leading to infinite billable hours spent on ethical, philosophical, and financial valuation. Imagine a character named Marcus, a successful biotech engineer in San Diego. During his 10-year marriage, he and his spouse invested hundreds of thousands of dollars in cryogenic preservation, not just for embryos, but for customized stem cell lines and genetic sequences designed for future longevity treatments. In a 2026 divorce, these are no longer considered simple medical waste. They are classified as hybrid assets. The legal battle over who retains control of genetic material is arguably the most complex litigation in the history of the U.S. court system. Attorneys are charging premiums that exceed even the international asset hunts we discussed previously, because these cases often require constitutional law experts alongside matrimonial litigators. The step-by-step revenue generation in biological asset cases starts with the status injunction. Attorneys bill dozens of hours just to ensure that the storage facility does not destroy or release the material while the divorce is pending. Then comes the valuation of potential. How do you value a genetic sequence that might hold the key to a future medical breakthrough or an extended lifespan? Historically, courts have struggled with this, which is exactly why it is so profitable for lawyers. They must hire bioethicists, medical researchers, and specialized actuaries to testify. Each of these experts bills at rates comparable to senior partners, and the attorneys bill for every minute spent coordinating this multidisciplinary team. In case studies from early 2026, the pretrial costs for biological asset disputes are reaching $500,000 before a single permanent order is issued. This leads us to the broader 2030 horizon of the automated arbitrator. While the elite fight over genetic sequences, the statistical history of the industry shows a massive push toward the total automation of the low to mid-tier market. We are approaching a historical tipping point where the $13 billion revenue engine will bifurcate permanently. On one side, you will have the commodity divorce. This is a state-mandated, AI-driven process where the algorithm scans your tax returns, your property records, and your children's school schedules, and then issues a final decree in 48 hours. For the average American, the role of the attorney in this scenario is reduced to that of a technician or a data verifier. The economic shift here is staggering. If 80% of divorces move to an automated system, the traditional small-town law firm model faces a total revenue collapse. However, The historical trend suggests that the legal industry is already preparing for this by shifting into the regulatory compliance space. Instead of fighting the AI, firms are positioning themselves as the only authorized auditors of the AI's decisions. They are selling a new product, algorithmic assurance. If the state's automated system suggests a settlement that a character named Sarah feels is unfair, she pays a firm a flat fee to run a counter audit. This is the new revenue stream, lawyers acting as the quality control for the machines. Furthermore, we must analyze the emergence of the marriage insurance premium as a factor in legal revenue. By 2030, the data suggests that matrimonial law firms will increasingly be funded not by the clients themselves, but by insurance carriers. Much like how a car accident involves insurance adjusters and defense attorneys, the future of divorce revenue may lie in the domestic liability policy. Attorneys are currently working with fintech companies to design these products. The revenue for the firm becomes a predictable B2B contract, rather than a volatile B2C retainer. This professionalization of divorce risk will stabilize firm revenues, but will also lead to a standardization of conflict, where insurance companies dictate which legal battles are worth the cost. We also see a fascinating trend in the divorce of things, or the Internet of bodily assets. As we integrate more with technology, our personal data becomes a biological record. In 2026, the records from a person's wearable health tech or their Neuralink interface can be used in custody battles to prove fitness or lifestyle habits. The revenue generated by the forensic analysis of biological data is a brand new frontier. Attorneys are billing for the time spent cross-referencing heart rate variability data with geolocation to prove a spouse was not where they claimed to be. This is the ultimate open loop in the industry. As long as there is new data to mine, there is a new reason to bill. Step by step, the industry is also moving toward the prenuptial smart contract. These are self-executing legal agreements coded onto a blockchain. In 2030, a couple might enter a marriage with a contract that automatically transfers assets the moment a divorce filing is detected by the network. While this sounds like it would eliminate the need for lawyers, the historical reality is that someone has to write the code, someone has to audit the code, and someone has to litigate when the code has a bug. The revenue shifts from the courtroom to the development lab. The divorce attorney of the future is part coder, part actuary, and part litigator. As we conclude this deep dive masterclass, the statistical history of divorce attorney revenues in the U.S. shows a clear and undeniable pattern. The industry does not shrink, it only transforms. When one door closes, like the standardization of alimony, another opens, such as the valuation of digital souls or the division of genetic material. The $13 billion spent annually is a reflection of a society that is becoming more complex, more litigious, and more focused on the granular division of every possible asset, both physical and metaphysical. The story of this revenue is the story of the American dream's shadow. It is the cost of uncoupling in a world where everything is connected. From the first no-fault laws in 1969 to the biological asset wars of 2030, the business of ending a marriage remains one of the most resilient, adaptive, and profitable sectors in the American economy. The machine never stops, it only upgrades its software. If you want to understand the next phase of this financial evolution, you have to look at the people who are funding the other side of the table. In our next series, we are going to look at the hidden world of private investigative empires. We will go behind the scenes with the men and women who provide the evidence that fuels these multi-million-dollar billable cycles. We will explore the tech they use, from satellite tracking to deepfake detection, and look at how the surveillance industry has become the silent partner in every high-stakes divorce in America. The war for the truth is even more expensive than the war for the assets. See you in the next deep dive.